Second-degree murder charges have been dismissed against a Florida man after a judge determined he was justified in his use of force under what is commonly referred to as Florida's stand your ground law. So be sure to stick around as we discuss the case, the law, and how the judge came to the conclusion he did. Hello everyone, and welcome to the Firearm Firm channel. I'm attorney James Phillips, a former prosecutor and founding partner of Katz & Phillips PA, also known as the Firearm Firm. For 78-year-old Edward Drusalowski, 2024 ended on an extremely high note when a judge determined that he was immune from prosecution for second-degree murder under Florida's immunity law, which protects those who are justified in their use of force in self-defense situations. According to Mr. Drusalowski's recorded interview given the same day of the incident, back in September of 2023, Mr. Drusalowski was inside his home when his wife told him that the neighbor's 42-year-old son, Brian Ford, was on their property cutting branches down from their trees. Mr. Drusalowski retrieved his .357 revolver and went outside to confront Mr. Ford. Once outside, Mr. Drusalowski noticed his gate was open and saw Mr. Ford on his property near a chainsaw. As he approached Mr. Ford, Mr. Drusalowski kept his firearm in his hand but behind his back out of the sight of Mr. Ford. Mr. Drusalowski asked Mr. Ford to get off his property, in which Mr. Ford told him to mind his own business, followed by, well, some not so nice words. At this point, Mr. Drusalowski pointed the firearm at Mr. Ford and once again told him to get off his property. Instead of getting off the property, Mr. Ford responded by saying, "You're pointing a gun at me? Are you going to shoot me?" and began moving towards Mr. Drusalowski. Mr. Drusalowski told him to stop right now or he would shoot, but when Mr. Ford kept walking towards him, Mr. Drusalowski pulled the trigger. Mr. Drusalowski told law enforcement in his interview that his revolver holds 6 rounds, but he only keeps the first 2 chambers empty for safety reasons. So when he pulled the trigger the first time, the gun only clicked, which he said Mr. Ford heard but kept advancing towards him. Mr. Drusalowski then pulled the trigger again, and this time the firearm discharged a round which hit Mr. Ford. In his interview, Mr. Drusalowski told law enforcement that he took his revolver with him for safety because he knew that Mr. Ford had been in prison. Also, Mr. Ford had previously told him about all the fights he won while he was in prison, so Mr. Drusalowski was a little scared of Mr. Ford. Mr. Drusalowski also told law enforcement that given his age and health condition, he could not protect himself against Mr. Ford if Mr. Ford decided to attack him. Mr. Drusalowski told law enforcement that he could not recall seeing any weapons in Mr. Ford's hands at the time of the shooting or even remember whether or not Mr. Ford had made any threats. However, when law enforcement found Mr. Ford's body, they found 2 knives near his right hand. Also, according to Mr. Ford's 8-year-old son who witnessed the entire incident, Mr. Ford had the chainsaw in his hand and threatened to cut Mr. Drusalowski's head off with it. Mr. Drusalowski could not remember those details when he was interviewed the day of the incident. Of course, I can't say for sure, but I do believe if Mr. Drusalowski would have told law enforcement that Mr. Ford had a knife in one hand, a chainsaw in the other, and threatened to cut off his head, he probably wouldn't have gotten arrested that day. This is why you should never give a statement right after the incident while you're still under the stress of what just happened. There's just way too many physiological and psychological things going on in your body right after a self-defense incident to be able to provide an accurate account of what happened. Most importantly, never, and I mean never, speak to law enforcement without having an attorney present or at the very least speaking with an attorney prior to speaking with law enforcement. I've seen way too many people make this mistake and it has cost them dearly. Even if you know you did nothing wrong, consult with an attorney first, please. Florida has a strong immunity statute that protects those who are justified in their use or threatened use of force from being arrested or prosecuted. The immunity statute is found in Florida Statute 776.032 and is titled Immunity from Criminal Prosecution and Civil Action for Justifiable Use or Threatened Use of Force. The pertinent parts of 776.032 reads, a person who uses or threatens to use force as permitted in section 776.012, which is our justifiable use of force statute, section 776.013, this is our Castle Doctrine statute, or section 776.031, defense of property statute, is justified in such conduct and is immune from criminal prosecution and civil action. As used in this subsection, the term criminal prosecution includes arresting, detaining in custody, and charging or prosecuting the defendant. The statute further reads that a law enforcement agency may use standard procedures for investigating the use or threatened use of force as described in subsection 1, but the agency may not arrest the person for using or threatening to use force unless it determines that there is probable cause that the force that was used or threatened was unlawful. In Mr. Drusilowski's case, law enforcement obviously did not believe he was justified in his use of force since they arrested him the same day as the incident. Like Mr. Drusilowski, anyone seeking protection from prosecution under 776.032 must file a motion with the court requesting the court to hold an evidentiary hearing to determine if he or she is entitled to immunity. In a criminal proceeding, once a prima facie claim of self-defense has been raised by the defendant at a pretrial immunity hearing, the prosecution must show by clear and convincing evidence that the person seeking immunity was not justified in their use or threatened use of force. According to case law, a prima facie claim of self-defense is an assertion that at a first glance is sufficient to establish a fact or right, but is yet to be disproved or rebutted by someone. As mentioned, once a prima facie case for self-defense has been made, the government then bears the burden to show the defendant was not justified in his use of force by clear and convincing evidence. Now, the burden of clear and convincing evidence is not as high as beyond a reasonable doubt, which is the standard the government must meet for a jury to find someone guilty of a crime, but it's still a pretty high burden. To give you an idea of how high clear and convincing evidence standard is, it is the standard or burden that is required for a judge to permanently remove a child from his parent. So, as you can tell, it's still a pretty high burden. After having a hearing on Mr. Drusilowski's motion for immunity, the court issued an order on December the 27th, 2024, finding that the government had failed to meet its burden of proof by clear and convincing evidence that Mr. Drusilowski was not justified in his use of force and dismissed the case in its entirety. As of the filming of this video, the government has not filed a notice of appeal and they have until January the 26th, 2025 to do so. Although I only have the order from the evidentiary hearing, I think it's important to discuss how the judge came to the conclusion he did and the factors he had to consider. There's no question that Mr. Drusilowski used deadly force since Mr. Ford died from a gunshot wound at the hands of Mr. Drusilowski. Therefore, the judge must first consider if deadly force was the appropriate level of force to be used. Florida Statute 776.012 subsection 2 allows a person to use deadly force under two circumstances. The first is if it is reasonable to believe that deadly force is necessary to prevent imminent death or great bodily harm to himself or to another person. The second time is when it is reasonable to believe such force is necessary to prevent the imminent commission of a forcible felony, which are listed in Florida Statute 776.08. As discussed in previous videos, Mr. Drusilowski's use of force is not judged by what he thought at the time, but instead is judged by what a reasonable, prudent person under the same circumstances as Mr. Drusilowski was at the time the force was used. So, the judge had to decide whether a reasonable person under the same circumstances as Mr. Drusilowski would have reasonably believed that such force was necessary to prevent imminent death or great bodily harm or to prevent the imminent commission of a forcible felony. One thing that is important is that Mr. Drusilowski knew prior to using deadly force that Mr. Ford had been to prison for a violent crime and Mr. Ford had a reputation for being violent in the community. Also, Mr. Ford had bragged to Mr. Drusilowski about all the fights he won while he was in prison. Another thing that is important is the disparity of physical abilities and capabilities between Mr. Druskalowski and Mr. Ford. Mr. Druskalowski was 78 years old at the time of the incident, had a frail build, and had major health problems, whereas Mr. Ford was in his early 40s at the time and had no known health problems. All of those things are factors contemplated in Florida's standard jury instruction for justified use of deadly force. Looking at the circumstances at the time deadly force was used, the evidence showed that Mr. Ford was advancing towards Mr. Druskalowski with a knife in one hand and a chainsaw in the other. Both of those objects obviously could cause death or great bodily harm to Mr. Druskalowski. Further, the evidence showed that Mr. Ford threatened to cut off Mr. Druskalowski's head, and he had the weapons to make good on that threat. So based on just that, it could be reasonable to believe that deadly force was needed to prevent imminent death or great bodily harm. Also, it would be reasonable to believe that deadly force was necessary to prevent the imminent commission of a forcible felony, with that forcible felony being aggravated assault. Now, there are other forcible felonies that one could argue Mr. Ford was committing at the time, but for time's sake, I'm not going to go over all of them. Based on everything, I think anyone could easily come to the same conclusion that the judge did. Be sure to let us know what you think of Mr. Druskalowski's outcome down in the comments section below, where you can also leave any questions you have about this video or any other Second Amendment or self-defense related question. Until next time, stay armed and educated.